Welcome to the Utah Home Builders Association podcast. I'm Jesse. I'm here with everyone's favorite builder, Ross. Ross, I want to talk about the Sheetz case today.
Yeah, so the Supreme Court's been really busy this season with cases that affect us. The Sheetz is a really interesting one that deals with impact fee studies. So it definitely is our area of expertise.
All right, well, a quick overview from what I understand of this case. It's about a gentleman in California named George Sheetz, and he wanted to build, I believe it was a 1,600 acre square foot, not acre. Oh my goodness. A 1,600 square foot home on his property. And he ended up getting hit with around a $23,000 traffic impact study fee.
Yeah, that sounds about right. I don't remember the exact details, but something in that. It was a little more than 2,300 or 23,000, and it's a case that's been going on for about 8 years. I want to say it originally started in 2016 or 2015, something like that.
It was 2016 is what I saw.
Yeah, so
that's a long time.
It is. So it takes a long time to work it all the way up to the Supreme Court. And it had to go there because with it being, they charged him the fee. He was just building a small home. The other interesting thing about the home is he wasn't even building the home. It was a manufactured home. And the reason he chose a manufactured home is because he's an engineer by trade and he's retired. And that's why you're thinking he's old, is because he's retired. As a retired guy, him and his wife wanted to go build this little house and live in it and raise their grandson. And so he went with a manufactured home because he dealt with the building process his whole life, and he wanted something that was easier. Most of the home was done elsewhere, so he didn't have all the inspections and all the things that would normally come with the house. So he was a little shocked when he got hit with this big impact fee, and he protested a little, but ultimately he says, no, I got to keep moving forward. So he paid the fee, but then he filed suit.
I think I would too. That is a huge amount of money. And for such a small home, that's not a large home. In this case, as I've been reading about it, I keep seeing something called a Nolan-Dolan. What is that?
So the Nolan-Dolan, and interesting how we get to where we are with so much of this. We're reviewing what now is a Supreme Court case, and so that kind of sets the law, sets our rules. It defines, I guess, the laws that are in place, and it helps it so everybody understands what they are. So Nolan and Dolan is a standard that's been set over the years by other Supreme Court cases. So it's the Nolan case and the Dolan case. And I guess they just sound so close, it just works that we go, oh, it's the Nolan-Dolan test. And what that does is two separate cases, but they together say that if the government is going to take away your property in an impact fee, and taking away money is the same as taking away property, that it has to have a nexus. It has to somehow be connected to the property, and it has to be a reasonable amount. It has to be something that is rational to what they're going to do. So it can't just be the government saying, oh, well, we think we need more money, so we're going to raise our impact fees. It has to be, we're going to raise our impact fees because it takes this much money to maintain the roads, for example. So,
all right, so what is a typical price for an impact fee?
Well, that's a great question. The problem with a typical price for an impact fee is it depends on your different city. So an impact fee usually works through a study process where they look at it and say, well, currently we have a certain level of service. So you would have a certain number, and let's say parks, for example, because it's easier to understand. In the Sheetz case, it was actually dealing with traffic, with roads. But parks are a little bit easier to understand. So we come into a city and we say, well, currently in the city, we have a certain number of people and we have a certain number of acres of park. So it becomes really easy to say the level of service is each person is getting this many square feet or this many acres or whatever it is of park. So then you can interpolate that number out and say, okay, if we add these 10 subdivisions and it increases the number of people here, the population goes up, then rationally we should raise the parks the same amount. So the idea of, well, what does one cost? It depends. If you're in a city that's almost all built out, it's not going to be near as much than if you're in a city that's brand new. So they have to do that study and see. There is no standard answer.
Okay. So why are they so expensive, though?
Well, because what we build is expensive. Cities sometimes misappropriate them. On this one, this case in particular, it was expensive, and this is what brought it, is because the county, and it was a county impact fee, not a city, and they needed the money because they were needing to do road repairs and way away from where he was at. And so they're sometimes expensive because you're saying, okay, well, there's a road impact fee. Well, to put in a new overpass or something like that is millions of dollars. There's so much money that can be eaten up so fast. And if you're looking at a little town where he was from, like Placerville, there's not a ton of building going on. So if you say, okay, we're going to figure out how to pay for this new road work off of just a handful of new permits, it's going to be a lot. But that's where it becomes a challenge, is that he probably shouldn't be paying to do that road. It should probably be a tax that is applied equally to the citizens. He's not requiring that road to be changed or rebuilt. So that was part of his argument, is it was too much. You're taking more than what it should be. And the interesting thing on this case is the county came back and said, well, right, but the Nolan-Doling test doesn't apply if it's a legislative act, meaning the county had gone in and within their statute, their ordinances, they had said, here's what we're going to do. So they had put that impact fee in ordinance and said, because of that, it no longer counts in the Nolan-Dolan test. We can set it for whatever it wants.
So are these impact studies and fees, are they really necessary? Like with building this new house, I'm assuming it was in a neighborhood that already existed. Wouldn't the impact fee have already been done, like by the city planner when they decided to put in the subdivision?
Some of them. And again, this one made the perfect Supreme Court case. That's why it's gone all the way up there. If we look at some of the others, though, and if they're done properly, the idea is that somebody comes in for to build a new subdivision, to build just a single home. And the idea is that if I'm going to move into your community and you've lived there for 15 years, during those 15 years, you've paid taxes the entire time. So when I come in, it's only fair that I pay some sort of a fee that puts me at equal ownership for whatever those amenities are as what you have already paid. The problem is when cities or counties or whatever that taxing entity needs more money, and so then they're no longer charging to put me on equal footing. Now they're charging to get what they want going forward. And so it becomes less of a buy-in and more of a, hey, what do we want in the future? And so then they become unfair, and that makes them very, very expensive. Because again, when I use the example of parks, if we're saying, okay, well, you get so many square feet per person for a park, but then one day the city goes, you know what would be really cool is this rec center. We're going to do a rec center with basketball courts and weightlifting and a pool, and we're going to charge that as an impact fee. That makes the impact fees crazy high. But this is where they're going, well, you're going to have to show how that works.
That makes sense to have to show it. Something else I've been curious about. What is the takings clause?
So the takings clause is in the Constitution, and what that says, and again, that was core to the argument on this, is that they're arguing that this was a takings. So the takings says that if you're going to take something, if the government is going to take something from the citizens, they have to provide reasonable compensation. So when we're talking about impact fees, the taking is cash. And so if they're coming in and doing that, it has to be to make it reasonable, what they have to do is provide a service or something back to that person that makes sense. And if you charge more than what it is, if you say, okay, well, the repair on the road is going to be $3,000 if it's divided up amongst all the citizens, but we're charging you $23,000, and that's a $20,000 taking. And again, that's where the county came in and says, yeah, but so long as we set that in statute, we're okay. So long as it's in our ordinance and everybody knows what it is, so they're not surprised, then we can charge whatever we want. And that's what the Supreme Court, it's important you ask about the takings, because that's kind of where they hung their hat on this, is they says, no, it's still a takings. Just because you put it in statute doesn't mean you can violate that constitutional takings clause.
So what does this mean for impact fees?
So for impact fees, I don't know. We will have to wait and see. What the court didn't do is they didn't get into how impact fees are calculated, and a lot of the details that oftentimes are kind of vague. The cities are figuring out, okay, well, what should it be and how do we make it work? How do we keep our city viable? Builders and developers are digging in and going, well, what do we do? How do we make this affordable? How do we build an affordable home? And the court didn't weigh in on that. The only thing, it was actually a fairly narrow decision, but it was still an important decision. But it was really narrow in that the only thing it said is that the cities, well, I shouldn't say cities, counties, special service districts, anybody that has the ability to charge an impact fee, they all fall under that same Nolan-Dolan test. They still have to follow the Constitution the same as anyone else. That they can't just say, well, we have the authority to make laws, and so we'll put it in a law, and then that way we don't have to follow it anymore, or we don't have to follow that requirement anymore. The court put a real bright line and says, no, that's not the case. You still have to meet those same tests. All those other difficult challenges with impact fees, we don't know. They didn't rule on it. We'll continue to struggle through that and figure it, and hopefully you get good, honest players at the table and everybody understands the importance of affordable housing. And so the impact fees, again, if they're fair, make sense. There's not a lot of opposition from the developer and the builder side for a fair impact. We want that to happen because we need healthy cities. That's where we go build. It's only when the cities get out of control that it becomes a challenge. So the Supreme Court didn't help us on that, and we'll have to just wait and see what comes next.
Well, I'm excited to see what keeps happening with this case and wish Mr. Sheetz the best of luck with this case.
Yeah, so good. So because you said that, and just to interrupt you real quick. So the other thing for George Sheetz is, so he spent, 8 years we decided, and he's ran this all the way to the Supreme Court. He won at the Supreme Court, but he's not done. All the Supreme Court did is push it back down to the lower courts and said, okay, here's a new ruling. You can't use this defense to say, oh, well, we're the government, therefore we can make the rule. You can't do that anymore. But he still has to go back to court again and try and get his money back. So when you say best of luck to him, yeah, best of luck to him. He's not done. I am sure that this has cost him many, many times more than when he gets his check back, which I hope he gets his check back from the county.
It's a lot of money.
But yeah, I think he has spent a lot of money and a lot of sleepless nights to get there. So yeah, good for him.
Well, here at the HBA, we think everybody deserves to be in a house. Let's build a solution together.